I wanted to talk to you about client confidentiality and attorney discretion. The reason I'm bringing this to your attention is because of something that recently happened to me. Not too long ago on a weekend, over the course of a weekend, I had a friend who's a trial lawyer call to discuss strategy for an upcoming trial that he had. Before I had a chance to ask who opposing counsel was or who the parties were, he launched into the intimate details about his case and also some details about one of the parties. Now here's the problem. First of all, I know opposing counsel very well. He's a friend. Second, I know the person who this attorney was inadvertently and in good faith sharing uncomfortable and probably confidential facts about. If he had thought it through, if he had a chance to do it over, I think he would have approached the situation differently. But this is what happened, and it's something we all need to pay attention to. We all need to be aware of. Things were said during this conversation that I don't think should have been mentioned or disclosed. And frankly, it made me wonder what this attorney has said to other people about things that we've discussed over the years. Once I figured out who he was talking about, I quickly interrupted him and advised him not to discuss this matter any further with me. I told him I had a personal relationship with several of the involved people, and furthermore that the disclosure of some of the information sounded to me as though it might be protected by attorney-client privilege. After getting off the phone, the conversation reminded me that it's impossible to overemphasize the importance of keeping privileged information confidential. At the same time, to be discreet with what we are told by clients, opposing counsel, and even judges. Look, it's our duty as lawyers, and it's our responsibility as professionals to maintain client confidentiality, to be discreet in what we do and what we say about our clients' cases. There's no doubt in my mind, and I've watched this happen, that you can quickly become the center of attention at a gathering or a party by discussing unknown information, things the general public is not aware of, with anyone who will listen. In many instances, the information may be very juicy and it will attract interest. In high-profile cases, in cases that we've handled in the past, lawyers are asked all the time for the inside scoop about a particular celebrity client or a professional athlete's off-the-field issues. If you find yourself in this situation, don't do it, okay? Don't discuss things you should keep to yourself, and in some instances may be legally and ethically required to keep confidential. When you violate someone's confidence, it can and will come back to nip you in the butt, or worse, okay? The best interest of your clients should always come first. Confidential and protected facts, issues, and communications should be respected and protected. That's your professional and ethical duty as a lawyer. There's a pretty good chance that when you do lack discretion in what you reveal and what you talk about with other people, those people who you share this confidential information with will, behind your back, wonder what you say about them when they're not around. If these people are also clients, the backlash of disclosing confidential information can and will be humiliating and embarrassing. Chances are you'll also lose business because of your lack of discretion. Always remember to maintain a respectful, professional, and consistent approach to keeping private matters confidential. Instruct and remind your support team of this important requirement long ago embedded in the foundation of our profession. Your unwavering attention to discretion and confidentiality will assure long-term confidence and respect from your clients, your friends, and your peers.